for joining us. Welcome. Sorry we held you back. But I do have I was mentioning at the last class, I was so sorry. Oh, what I wanted to say first of all is those people are really trying hard with their film to get it all around the United States. And this is their Facebook and Twitter messages. If any of you use social media, if you grab one of these on the way out, maybe send a message that if you like the movie, just let them know that. I think it'd be a cool thing. We were talking at one of the previous classes that we didn't have any sessions on climate change this semester and how important it was. And one of the things my wife is always nagging me about, I love my wife, is the fact that I don't recycle well. You know, I always put the wrong thing in the wrong pile. Does anybody have any, you know, and no matter how many times she tells me, I always do it wrong. So it's come out, there's this big article, you can grab it on your way out. Bill Roll will hand it to you on your way out in the Wall Street Journal, talking about the fact that a lot of recycling isn't even recycled, it's all sent to the landfill. A lot of it's just a big farce. And I just found after all the abuse I've faced, I found it just appalling to me, and I wanted to share this article with you. The last thing I wanted to share with you before we have our great presentation is something that I happened to catch on Twitter a week or so ago. Jay, if you would put it up. And does that guy look familiar right there? Bill Cunningham. And this is what it said. It said, in about 3 weeks, Dr. Kriakis at Christ Hospital will replace my aortic valve. Penny and I have gone through days of tests to determine the best course of action. No coronary artery inclusions, no thickening of hearts, just need a new valve. We are optimistic and ask for your prayers. So, gosh, I've sure listened to him a lot over the last 20 years. Mostly when I'm interested in city and county issues and he has guests on, I really like to hear them. I've got a card, I'm gonna pass it around. I'd like you to ask that you sign it. There's some blank 3x5 white cards on the chairs. If you would want to send him an encouraging message, if you listen to him, if you feel like you'd want to do that, I know it would be very appreciated. And we've got kind of a backdoor channel. We're going to get this to him, and at the same time, we are going to give him an Empowered Citizen Award for 2019, and here's what it says. To a great American who is informed, engaged, and entertained listener since 1983. You are an empowered citizen, which he surely is. So if you'd sign his card, send a message, I'd appreciate it. We'll get that to him in a backdoor channel. It ain't an easy operation. I know my dad had one, so it'll be hard. Should be fine, but we wanna send him his prayers. With that in mind, we're gonna start our presentation tonight with our great guest speaker. I'll pass that around in just a minute. So we're gonna hear from Sean Maloney tonight. Who heard him on the radio today? Wasn't he great? He's a defense attorney and member of the National Association of Criminal Defense Lawyers who practices in all areas of firearm-related law, including Second Amendment rights, criminal defense, federal and state restoration of gun rights, and federal NICS appeals. He's appeared as an expert witness in a variety of civil lawsuits related to firearms. As an attorney, Sean's law practice focuses on defending the rights of law-abiding gun owners who are forced to use their firearms in self-defense through Second Defense Call, which he founded, which is his website. He's also a member of the board of directors of the Buckeye Firearms Institute Association, a great organization that is going to actually have one of their upcoming meetings in this room, I believe, in May. We look forward to having them here. Sean was instrumental in winning back lost gun rights in Ohio through his efforts as a lobbyist, legislative director, and media spokesman. Sean is a passionate defender of the Second Amendment. Let's welcome our guest speaker, Sean Maloney.
Thank you so much. Can I steal this? Sure. I'm afraid I'll knock this over. One thing that I just accomplished, and was one of my bigger accomplishments, I guess, was satisfying was, I don't know if anybody is aware of that, in the city of Cincinnati, they banned trigger enhancers, bump stocks, and anything to do with making your firearm shoot better and more accurately. So Buckeye Farms Foundation and myself and Attorney Ron Lemieux, we sued the city of Cincinnati and Columbus under the preemption lawsuit that we just strengthened this last session. We won 2 weeks ago and they didn't appeal, so. And I feel sorry for the taxpayers of the city of Cincinnati because they have to pay my attorney's fees. But, thank you. I'm going to start out with a little history lesson. I want to talk about really where we came from as citizens in the state of Ohio regarding concealed carry. Certainly looking over this room, I think most of you remember back to pre-2004 when we didn't have a right to choose how we want to protect ourselves. And I have to point out, because I am an attorney, that this seminar is for entertainment purposes only. If you need legal advice, seek out legal advice and retain an attorney. Anything I say tonight won't create an attorney-client privilege or relationship, mostly because you're not paying me. And also, there'll be new books coming out. Anybody who's a concealed carry holder, Ohio's concealed carry laws and the application, the Ohio Attorney General publishes this every time new laws come out. March 28th, 2019 is when House Bill 228 will go into effect. So make sure that they won't put it on any sooner. Make sure you get online or stop by the local sheriff's office and ask them for a copy of it, because as soon as the sheriff's office gets it, they'll set it out, but it'll be available immediately online. I always try to point that out. If anybody in here, and I don't want to know who or if anybody owns a bump stock, March 26th, they got to be destroyed or turned in. So they really can't keep track of that. Let's talk about how Ohio became a shell issue concealed carry state. What shell issue means is if you're not otherwise prohibited because you have a federal firearms disability or some other conviction and you apply for your concealed carry permit, the state of Ohio shall issue that permit. It's, if you look at may issue states like New Jersey, they may issue it to you if you give somebody the right amount of money or you know somebody. Same thing is true for parts of California and New York State and many other states. If you recall, prior to 2004, we didn't have a right to concealed carry in the state of Ohio. But the good thing was, in Ohio's Constitution, since the middle 1800s, it was the constitutional right to open carry in the state of Ohio. Now, quite simply, what open carry is you're carrying a firearm over your shoulder, on your belt, open for the whole world to see. If you're not under a firearms disability and you can own and possess a firearm, you can do that without a permit. There's no permit required. It's your constitutional right as an Ohio citizen. And that's been working out well for nearly 200 years now. That open carry part, and the fact that it's constitutional, I think will eventually down the road to constitutional carry in the state of Ohio. If you've been watching the news, Kentucky just passed that. In fact, 3 states this year have passed constitutional carry. The fact that we're non-felons and we're citizens of the state of Ohio or Kentucky, and more particularly citizens of the United States protected by the Second Amendment, gives us a right to carry a firearm, however, in whichever manner we want to. Then in 2004, concealed carry was passed. If anybody was paying attention back then, can anybody remember who the governor was in 2004? Bob Taft. Bob Taft vetoed concealed carry in the state of Ohio 3 times. And it was almost impossible to get a bill to pass. And so what happened after the last veto, John Husted, now our lieutenant governor, called everybody back at 2 o'clock in the morning in the state of Ohio, the House of Representatives, and for the first time in I think 70 years, overrode a governor's veto. And that's how we got concealed carry. If you can remember what the concealed carry laws were like back in 2004, they were very, very restrictive. As an attorney, people always used to ask me, what are the laws in Texas? Or what if I go to Indiana or Kentucky? I used to tell people, if you pretend you're in Ohio, everywhere you go, there will be no trouble, because Ohio is the most restrictive state, bar none, dealing with concealed carry. And then over time, for instance, If you're a concealed carry holder under the first bill, the first law, and you had someone under the age of 18 in your car, you couldn't carry. Well, why do most of us carry? Protect ourselves and our families, right? Well, that's how the law was in the beginning. If you were a concealed carry holder back in 2004 when the law first came into effect, you weren't allowed to carry if you had your kids under 18 years of age in your car. And quite simply, it was so restrictive because they were trying somehow to get some bill passed or any bill passed that the governor would sign off on. And that never happened, so it took a veto override to take care of that. Like I said, it was finally overridden. It was a historic vote to finally bring the state of Ohio into compliance. Now, depending upon what website and what organization you look at, they rank concealed carry states and gun-friendly states. Ohio is actually, based on last year, number 29, which is huge because most of my existence in the state of Ohio, we were almost dead last, or usually around 39 or 40. And I suspect that we're a little bit higher because of some changes that we made that we'll talk about here tonight. One is a pretty big one, and I think that'll move us way up. It was kind of easier and simpler. We're not in a simple time anymore for a lot of different reasons. The way our government's ran, the way people interact with government, the way socially we interact with each other. What really changed, probably in the last 10 years, was a gentleman by the name of Michael Bloomberg. Michael Bloomberg started a number of different anti-gun organizations. And what Bloomberg brings to the table that nobody else does is the fact that he's a multi-billionaire. For instance, when he started Everytown for gun safety, he infused $50 million into that organization. $50 million. Well, really isn't a whole lot of money considering he spent about $200 million to get elected mayor of New York City. But with that, Moms Demand Action were funded by him. The Brady campaign, which is still active, was funded by him. Americans for Responsible Solutions is a super PAC that was founded by Gabby Gifford, again, with millions of dollars, affecting your civil rights or God-given rights to self-defense. In a number of other organizations, there's a big organization out there that's really comprised of 48 smaller organizations, including churches and other local organizations that are out there. He also created Mayors Against Illegal Guns. Through campaign finances, through donations, through lies, I would probably have to say also, or twisting the truth. He recruited a lot of mayors throughout the United States to pass his anti-gun ordinances, his anti-gun legislation, and just make their cities and municipalities anti-gun organizations or places to be. And Cincinnati, unfortunately, ran basically by Mayors Against Illegal Guns. That's where the lawsuit that we sued came from. That's where a lot of the anti-gun legislation came from and ordinances. We have a thing in the state of Ohio called preemption. And we'll talk about preemption because this last bill, House Bill 228, expanded the powers of preemption, and the people that hold the powers of preemption are you. And we'll talk about that. And that's the only thing it's probably been able to help us to fight the Bloombergs of the world. And I want you to consider, all these groups are outside interest. None of them, not one of those organizations was started in the state of Ohio. Now, Moms Demand Action with Bloomberg money, they've started to kind of mobilize in certain big cities, and Cleveland was the first one, but now they're kind of creating little groups and organizations similar to, I compare them to the Tupperware parties my mom used to have. Everybody gets together, but now they're Moms Demand Action parties. They get their marching orders, and it's interesting if you're at a committee in Columbus in the State House and they testify against committee, they're going to come up and they're going to testify against AR-15s. It doesn't matter that that's not the issue, but that's what they always bring up because they have their little script and they try to stay by that script. But you have Moms Demand Action, several different Bloomberg books or groups that I talked about prior to this, and they all are now coming to the state of Ohio. Back in 2004, when the battle and discussion was about concealed carry, open carry, and strengthening our firearms rights, it wasn't outside organizations coming in trying to tell us and our legislators what to do. It was Republicans and it was Democrats having a civil discourse on what they want. And around that time, or prior to 2004, if we can think back that far, gun rights wasn't a partisan issue. Certainly before that time, you had just as many Democrats as Republicans that supported the right to keep and bear arms and the right for all of you to protect yourselves. Over time, and I think it's increased, it became a partisan issue. People, can anybody remember Ted Strickland? Whatever you think about Ted Strickland passed the biggest bunch of pro-gun legislation that was ever passed in the state of Ohio. Ted Strickland was great on my issue and your issue, right to keep and bear arms and protect yourself. And he strengthened and made so many great changes to concealed carry in the state of Ohio. It's kind of unbelievable. Now he kind of went off the track when he left the state of Ohio, but I always point out that it wasn't a partisan issue, and it doesn't belong to be as a partisan issue. But the problem is, all of a sudden, it's not about Hawaiians anymore caring about their rights and each other and how they're going to protect themselves and their families and their civil rights. It's outside influences and outside organizations that are coming in here and causing the problems. Really, they're spending millions of dollars. They're muddying the waters. They're clouding the issues, and you have to sort through the propaganda now to try to figure out, what the truth is behind the gun legislation that's being introduced. Certainly, Buckeye Firearms Association and Ohioans for Concealed Carry, they do as best as they possibly can to make sure we educate people. Education is the first thing to do, but there's so many other groups out there now, and with social media and with contacts from emails, you can imagine how things get really confusing and the lies start coming up, and they start confusing legislation that's trying to be passed. It's a huge amount of money from the outside that's doing this, and unfortunately, it's difficult at times to sort things out. Now, who's aware of the lawsuit, Madison Schools in Butler County, Ohio? If you remember 2 or 3 years ago, there's a shooting in Madison, and one of the schools, along 8th or 9th grader, brought a firearm in his backpack, waited until Sheriff Rick Jones's school resource officer left the cafeteria, pulled a firearm out, and shot one of his classmates. Probably within 10 minutes, Sheriff Jones was on TV, and he had this words of advice. He said, "Parents, you have to demand that your teachers are armed. Somebody else has to be in that school to take care of your children, because even when we're there, we can't be there." And so shortly after seeing the hook, Buckeye Firearms and I was a leader at that time also, we all had a conference call that night because we knew it was going to happen again. And I can tell you there'll be another school shooting. There'll be another church shooting. It's going to happen again because it does. Not because the firearms are evil. We have a tremendous mental health problem in the United States that nobody seems to know how to take care of right now. And things are going to keep happening like that. Well, we had a telephone conversation. Some of us were crying. What can we do to stop this? And we started a program called FASTER, which stands for Faculty Administrator Safety Training and Emergency Response. Essentially, what Buckeye Firearms Foundation does is that we raise hundreds of thousands of dollars every year. And we send teachers to Chris Serino near Akron and to John Bender's TDI in Brown County or Adams County in Ohio, where they undergo intensive training by the world's experts, teachers, janitors, bus drivers, administrators, how to properly use firearms, how to disarm and defuse the situation, and they're also first responders. They know how to use tourniquets, chest seals, and they know how to save lives after this happened. Well, it's been a very successful program. Probably 2,000 teachers have been through it in the state of Ohio. I believe it's well over 20 states that we've had other people visit these classrooms. Sheriff's departments from the state of Ohio have been there. We've trained many people. I think we're probably up to 70 or 80 counties now have FASTER trained individuals in the schools in the state of Ohio. The Ohio Revised Code provided that You could have guns in a school safety zone, but it was up to the school board. The school board could vote to allow, pass a resolution to allow firearms within the school safety zone. That way federal law wasn't being violated. Then it was up to the school to choose who they wanted to carry firearms, if they so chose. And then to determine what kind of training they wanted to do. So local control. I mean, finally we had, local control in our schools are so important, and we've seen over time what the lack of local control does. So the parents in Madison School District made the decision, the school board made the decision that they were going to allow firearms in the school safety zone. They're a rural school district, and they understand that, help is going to be 50 minutes away. And so at that point in time, they voted to arm their teachers. Now, certain people within a school district didn't understand that whenever a school board discusses things that deal with the health and safety of its students, it has to be done in an executive session, because you don't want to be talking about school security in open public, and so the bad guys know what's going on. And that's why that law is in effect. So all the decisions were made. They had meetings about it before and afterwards. And then somehow Michael Bloomberg found out about it. Brings every town for gun safety in, and hires some attorneys from Columbus, Ohio, and sues Madison School District. Madison really didn't have the money to defend that lawsuit. They got Frost Brown Todd as a law firm, a great law firm, but still their insurance is only going to cover a portion of what the lawsuit was going to fund. So Buckeye Firearms Foundation, we stepped in and we donated $25,000 immediately to help them defer the cost of that lawsuit. We found out probably 2.5 weeks now that we won that Madison case. So we send Michael Bloomberg packing, but who knows how far away he's going to be. But if you look at the fact that an outside interest group, not even related to anybody in the state of Ohio as far as their kids, they're not taxpayers, they don't vote, they didn't decide that what was best for the school district, came in and sued to defeat the will of the people of Butler County in the state of Ohio. Makes no sense, but when you have billions of dollars to spend, that's what ends up happening. You have a question?
Could you hold on just a second, please, ma'am? Would you ask your question on the microphone so the people online can hear?
Marcia, don't you have to have standing to do some kind of a lawsuit?
Yeah, I did. They found people who lived in that school district and made them their plaintiffs. There's always somebody that doesn't agree, and he came in and found somebody that didn't agree, and that's how they got standing, and they sued on behalf of them. So, and that's bothersome, and it goes back to the point in time, all these outside interests now are moving in to control our will and what we decide is best for us. And so the lesson of this part of my presentation is you got to keep your foot on the pulse of what's going on around you. Every time you get out of bed in the morning, you have to understand that someone's trying to defeat you and someone's trying to take your rights away. You have to stay engaged. And the fact that Dan does this for everybody in this room is a great way for all of us in here to stay engaged and discuss these things, because it's so important. I'm not sure, I try to stay on top of my kids, and eventually I'll try to stay on top of my grandkids, but we have to stay involved in the government, because we're never going to get the government we deserve. We're only going to get the government we work for, and we have to keep working, and we have to make sure that we stay walking down the path that we intend to, and not let the Michael Bloombergs of the world decide how big our Coke is or if our kids are going to be protected. That's so important. Now, does anybody have any questions so far? Yes.
Hold on just once.
Edwin, you said that there was rankings of number 1 through 50 of most firearm-friendly states. Which one is number 1 and which is number 50?
You know what? I can't exactly remember. New York State was number 51. So I don't know what else is in there. But yeah, well, you know what is DC? So DC's lower, and I believe it's either Alaska or one of the constitutional carry states out there that are most gun friendly. If you look that up online, you can find that, and I'm sure somebody watch this online is going to look at it right now. But It was in Guns and Ammo magazine, did the latest study that I looked at, and I found that on ammoland.com. So there's a lot of information out there. And they look at everything, how easy it is to get your permit, how expensive it is, how easy is it to buy a firearm, what do you have to go through? For instance, in some states, you have to have a FOID card, which is a firearms identification card, essentially. Right, so you have to get your FOID card. In Illinois, if you want a concealed carry permit, folks, you're looking at over 2 days of training. And it keeps very onerous and becomes very difficult. And of course, there's the states like New Jersey and New York State where somebody picks and chooses who can carry a firearm concealed and who can. Very few people can.
Sean, I've got 2 questions from online. First question, where do we stand on duty to retreat?
Duty to retreat is a great story, especially if you're John Kasich fan. We had duty to retreat was in House Bill 228, along with a provision that dealt with the problem of promptly informing a police officer. The reason, if you're pulled over, if you have any meaningful firearms contact with, with law enforcement, any meaningful contact, whether you're driving, you get pulled over for speeding, you're the passenger in the car, or you're walking down the street and a police officer stops you to ask you questions and you have the firearm on us, the law states that we have to promptly notify the police officer. The problem is, if all those little index cards you had to write little messages on, if I asked you all to write the definition for promptly, they would all be different. So now we are tasking our police officers to make a determination of what promptly was when they have a different meaning of what the driver of the car is, the person stopped on the street. So essentially many states, I think 32 states or 36 states require, if you're asked by police, do you have a firearm? Well, then you respond. And the majority of the other states, they require that once the police officer asks you for your identification or your insurance or registration card, then you have to, that's the line in the sand, you have to hand them your concealed carry permit with your driver's license or inform them that you're a concealed carry holder and the firearm is with you in the car. So those changes are very common sense, and we're just trying to make it less cloudy for both the police officers and for us, the law-abiding citizens, to make sure that we knew what the law was. So that was in House Bill 228, and also we were removing the duty to retreat. People call it stand your ground. It's not your stand your ground. That's a media-created term, but we were going to remove the duty to retreat. And I always point out to people, the duty to retreat or, quote, stand your ground never comes into play until you made a simple determination. That determination is that you're in fear of immediate, unavoidable death or serious bodily injury or harm. I'm about to be killed right now. It's going to happen. It's imminent. It's imminent. Once I make that decision subjectively, personally, that's the way I feel, then, and only then, does thoughts of lethal force come into play. And then the duty to retreat or quote unquote stand your ground comes into play. So until you've even made the decision that you're in fear for your life, that doesn't come into play at all. And then at that point in time, and I always define that is if the only way to get yourself out of the situation is by using lethal force, then it's time to use lethal force if that's what you choose to do. So that was in House Bill 228 also. Well, John Kasich was also pushing one of the most restrictive liberty-robbing red flag law that was in existence. A few states have these things, and when he was demanding that his senators and his quote-unquote representatives pass was a red flag law. The law was a mess. It totally robbed everybody of any due process privileges. Someone, an anonymous tip could make the police kick your door open and seize your firearms. So the House and the Senate said there's no way in the world we're going to pass this. We're just not going to. It's not constitutional, and we're not going to. And he says, if you don't pass it, I'm going to veto House Bill 228. So they knew the veto was out there looming, and members of the president of the Senate and the Speaker of the House, they know where their votes lie. So at the last minute in the lame duck session, really the night before the vote, it was announced that they were going to strip the duty to retreat and the correction to promptly notifying out of the bill, because if that was in House Bill 228, it was not going to be veto proof. It would have passed, but there wouldn't have been enough votes to override the governor's veto. So those two things were removed, and then House Bill 228 passed. And I can tell you right now that removing the duty to retreat will be a priority in this session coming up. So legislation has been drafted. It was drafted probably 2 years ago. So that's sitting and we're waiting to institute that. And I'm hopeful that we used to be lucky if we got a gun voting session within 2 years when Kasich was there. Hopefully every session will enact some new gun laws to straighten things out, but that's coming up on the horizon.
Okay, one more question, Sean. Are we anywhere close to enacting constitutional carry?
Just spent about 2 hours on the phone about that today, yesterday, the day before. Went throughout the House and Senate shortly after the elections, introducing myself to the new representatives and new senators. And the people I bumped into that I've known for years, whether it was Larry Householder, who's our current speaker, or the Senate president, they asked us, what do you think about constitutional carry? So we had well over a dozen people, probably 20 or so of our representatives ask us, what do we think about constitutional carry? We had a meeting today where that was a priority with the governor's staff and the legislative staff to let them know, well, what do you want? Well, constitutional carry. So constitutional carry, we're going to work very, very hard on. It's going to be a priority, and it may turn out being really the only piece of legislation, pro-gun legislation, that we're going to run. That's how serious we are about constitutional carry.
We have a question right here.
I am John Becker. I'm a state representative. I have a question. Sean, we get these horrific mass shootings that occur from time to time. You know, most recently, of course, there was one in New Zealand. And as you know, we've had several in this country, whether they're in churches, schools, or wherever they happen to be, and every one is horrible. Of course, what you wind up with is a lot of emotional people, and for good reason. And, you know, they're demanding some type of action. You know, we have to do something. You know, and nobody needs to own military-style weapons. Nobody needs a semi-automatic. Nobody needs magazines that can hold 30 rounds, 50 rounds, 100 rounds. The list goes on. How do we deal with that kind of emotion? What are your recommendations?
You know, it's a constant expected knee-jerk reaction because if you're taking it as being sincere, they want to do something. They don't know what to do, and so the easiest thing for someone to do is to attack our firearms, is to strip off of our constitutional rights. Again, I think, as I mentioned before, there's so much, I think, that goes into this issue. We've had a total failure in this country of mental health. You look at people that are living under bridges, they shouldn't be there. They're there for a reason, and what happened in the 60s. Then you look at our HIPAA laws. If your doctor determines that you really shouldn't have firearms, or you shouldn't be driving a car for whatever, for psychological or mental reasons, you have to be adjudicated as mentally deficient before you lose your gun rights or before you can be made safer in the community. Well, it never gets to the courts because you have HIPAA laws where the doctors can't say anything. So I can be nuttier than a fruitcake. My family could want to take me and have me adjudicated mentally deficient for the safety of myself and society, but the system's broken down and they can't. You have to slow these people down. And unfortunately, Representative, the problem that we get, and you see it every day, is that it's the emotion that comes into play. And it's not our emotion anymore. And it ends up being all these outside forces are telling him how to pass our laws and what they want. And so we just have to try to take a breath. You can try to have a rational discussion with them, but it's very difficult to have that rational discussion because they don't want rationality at this point in time. You kind of have to learn how to argue or save your breath and not argue. But you have to point out that, hey, we're law-abiding citizens, and truth be told, the FASTER program, and if there were someone with firearms in these churches and these mosques and these schools, Wayne LaPierre said it best. I'm sorry if you don't like it. The only thing that stops a bad guy with a gun is a good guy with a gun. And that's what happens. And fortunately, what we have to do is we have to call Representative Becker. We have to make sure that he knows, he gets the emails, and he can stand up and say, my people are supporting me. We can't leave these guys out there hanging because they have to know that they're doing what their constituents want. And unfortunately, we kind of sit on the couch a little bit more than we should. And we don't make phone calls, not all of us, and we don't visit Columbus, and we don't send emails. But our legislators, they need that protection. They need that help to know that they're defending us. So that's so important we do that. Unfortunately, all these outside forces are paying people to call and make calls to the State House, and who knows what states they're from. But I know it's happening. But it's important that we support the people that we elected. We make sure that they know where we stand on this issue, and we let them all know by the telephone that they, we got their back. Do you have anything to add? So,
Sean, we have another question here.
Do you want to ask?
So on the topic of irrationality and emotions running high, going back to Ohio being open carry, how does that affect if you are open carry in a place you're allowed to open carry, considering all of the emotions, can you still get arrested for inducing panic for that?
what was the question?
Can you still get arrested for inducing panic if you open carry?
No, probably 15 years ago, I stopped, I'm a terrible businessman because I would get phone calls on a constant basis for somebody that was open carrying in Cincinnati, Ohio, that had been arrested for making an offensively coarse gesture for open carrying their firearm, doing something they had a legal right to do. And I got so many of them that I couldn't charge these people anymore because I knew what they were doing, they had a legal right to do, and I just couldn't do it. I walked into the first case and looked at the prosecutor and said, what's making an offensive coarse gesture have to do with my client legally and constitutionally open carrying his firearm? Well, he can't do that, it's a gun. I said, but it's legal. No, it's not. Yes, it is. No, it's not. Yes, it is. Show me in the code where it's illegal. They couldn't. Open carry is legal. And I kept going down there over and over and over again with the same argument. Cases would be eventually thrown out, or you'd be in mayor's court, and who knows what was going to happen in mayor's court. But it's a legal activity. I can tell you stories about mayor's court. It's a legal activity, and now they know that. But was it Police Chief Craig, the police chief that moved to Detroit? Probably 2 years before he left, and Open Carry Cincinnati was probably responsible for this, a great organization who did a lot to protect that. He wrote a memo that he gave all his police officers and let everybody know that, hey, wait a minute, open carry is a legal activity, and there will be no more disorderly conduct tickets written for open carrying. You can't do that, it's legal. Can anybody tell me what making an offensively coarse gesture is? That's what they were charging everybody with that were open carrying. Any guesses? Back in the 60s. Now I'll block the screen for the online people, an offensively coarse gesture people, and that's what they were charging people with, disorderly conduct, making an offensively coarse gesture. And I said, you've got to be kidding me. But they would arrest somebody, they would haul them into the police station, and then they're going through the Ohio Revised Code trying to figure out what to charge them with. And somebody somewhere said, hey, charge them with this. And that's what they did over and over and over again. So that's a good question. Most of that stopped after that memo. And certainly the more concealed carry got out, the more we realized what the gun rights were, the less we put up with stuff like that. And that's how change happens. Any other questions before we move on? Talk about preemption. Is anybody familiar with preemption? Preemption laws essentially state that gun laws have to be uniform throughout the state of Ohio. We can't drive from county to county, from city to city, and not know what our gun rights are because Cincinnati has a different law than Middletown has, than Westchester Township has, than Springdale has. All the laws are going to be uniform. And if, for whatever reason, the city of Cleveland decides to ban guns in their park, and the city of Cincinnati decides to ban trigger enhancers, and the city of Columbus does the same thing, well, they violate preemption. And what the preemption laws allow is for groups, for organizations, and for each and every person in this room to bring a civil lawsuit against the offender, whether it's the city of Cincinnati, Columbus, whoever it may be, for violating your rights because they changed the law. They don't allow a firearm in a park where they're legally allowed to be, or they ban pink guns. Whatever it is, the laws throughout the state of Ohio have to be uniform. Well, when they violate that law, then we as citizens, as groups and organizations can bring civil lawsuits against those entities. And if they lose, they have to pay attorney's fees. And Mr. Becker and his friends this past year expanded that to all reasonable costs and expenses for expert witnesses. If you have to lose time of work to bring this case, you're also going to get reimbursed that. So they really gave teeth to preemption. Now, I also want to bring in the city of Columbus and what they did today. And I'm not sure if you're aware. Are you aware what they did? The city of Columbus is suing the state of Ohio for strengthening preemption laws because we used preemption against them in probably June or July was when we had the lawsuit against the city of Columbus. We won that immediately when we were at the preliminary injunction stage. You know, they won that and they have appealed that already. So maybe that was the thorn they had stuck in their paw that made them sue the state of Ohio for strengthening preemption laws. And it's going to be a very interesting case to be involved with because I can't wait to hear their argument. I'm not sure what it's going to be. You may know a little bit more than I do on that thing. I just got it and I read the complaint and I started calling everybody I knew. I said, we got to get involved in this one. This is going to be fun. And then I said, a lot of times when I go over the changes to Ohio law that have been instituted, a lot of them have a lot of meaning. Everybody was waiting for them to happen, like removing the duty to treat and things like that. This time it's a little bit boring. It's a little bit boring, but this next thing was huge. When I first brought this next thing up 10 years ago, they laughed at me and said, this will never be done. It's called burden shift. I'm not sure if you're all aware of it, but the state of Ohio was the only state out of 50. So we are the only state that placed the burden of proof in a self-defense incident first on you, the defendant. Notice I said a defendant. Someone kicks your front door open at 2 o'clock in the morning, you roll out of bed, they're screaming at you, running up the stairs with a knife, an axe, a gun in their hand, and you shoot to stop the threat. They're now the victim and you're foyer on the ground and you're the defendant. Well, under our law, the burden by preponderance of the evidence to prove that you reasonably and properly use self-defense was on you. In every other state, it was like our founding fathers intended it. The prosecution has to prove each and every element of the offense charged beyond a reasonable doubt. That's what we always thought there were. Well, I met dozens and dozens of attorneys who didn't know that's what the burden was. I argued with certain members of the House of Representatives who were prosecutors that told me that wasn't the law, and it was. And that was passed, and that's probably without a doubt the biggest thing that happened, that we no longer, as law-abiding citizens who use a firearm in self-defense, we don't have to prove anymore first that we reasonably acted. And that's a huge victory. Unfortunately, it's a victory that probably most people are never going to have to take advantage of, and a lot of people didn't know it even existed. Like I said, I was going from chamber to chamber one day, and it was amazing that nobody would believe us. They didn't believe that we were that way, and in fact, we were. Then, does anybody have any questions about the burden shifting? That was important to get that done. And see, you have the advantage of having Mr. Becker. He can tell you about the backroom brawls. I wasn't involved with all that. I might have stirred some of them up, but he had to fight the battles for me. The next thing had to do with Ohio's definition of a sawed-off shotgun. And it was a very, very, very old definition, and it didn't comport with guns that were being manufactured and firearms that the federal government said were legal to be sold in the states. Ohio's sawed-off shotgun law was very old and hadn't been changed. Mossberg had a shotgun, and Remington had several shotguns. It was a Mossberg Shockwave that had a pistol grip, and it was a shorter shotgun. It was over 26 inches long, so legally under federal law and a Firearms Act, it could be sold and you could purchase it. Reading the Ohio Revised Code, when I went into my buddy's gun store, Right to Arms Firearms on Route 4, I went in there, I saw this on the wall. I was looking at it and I said, is that legal? And he said, yeah, here's the paper from the federal government. The ATF says it's legal. It's fine the way it was manufactured. It's over 26 inches long. And so just for the heck of it, I went back to the office and I started looking at the firearms law. And I noticed that in the state of Ohio, you couldn't have anything shorter. You couldn't have a barrel as short as that barrel was. The barrel was only 14 inches. The gun was over 26 inches, but the barrel requirement in the state of Ohio, shorter than that short, made it a sawed-off shotgun. And so I wrote a memo about that, and Buckeye Farms published it. And Attorney General Mike DeWine office contacted me. We drafted a piece of legislation a couple years ago, and we got it passed. And it simply took care of the definition. It didn't do anything screwy, and it aligned us with the other states and with federal law. Because I said, Mike, you allowed to sell this? And he said, well, the federal government said they're legal. I said, I don't think they're legal in the state of Ohio. So there's a bunch of people running around with shotguns that weren't legal in Ohio that they purchased over the counter. Not that there was going to be anybody with a tape measure on the side of the road or at a shotgun range. So we fixed it, so we thought. And then shortly after it was voted on by the House and Senate and veto overrides were done and everything was taken care of, they realized that when LSC, who was in charge of actually drafting legislation, when they put that piece of legislation in place, they put it where the first place where it belonged. And so when I reviewed it the night before at 10 o'clock or 11 o'clock at night, when everybody reviewed it, there it was. That's where it was supposed to be. No one bothered to turn the page because we had read this thing 1,000 times. It had been around for 2 years. And the next page had nothing to do with it. But on the next page, there was a cut and paste error. And they pasted that section, making everything legal under the dangerous ordinance provision, meaning it was now a dangerous ordinance and just about everything else was a dangerous ordinance at that point in time. So then we were trying to keep it quiet, and the House and the Senate was working on it. It was going to be all taken care of, and some group or organization found out about it, and the sky was falling, and everybody's guns were going to be seized, and everything was illegal. It wasn't going to happen, but it was taken care of in due course by the House and the Senate, just like it was supposed to be done all the time. I testified again in front of the committee, and we're human beings. Things happen, and someone pasted when they should have cut. But now it's all been taken care of, and it was done as a piece of emergency legislation, so it doesn't have to wait the 90-day period of time. And so it's my understanding of the procedure, in a split second, when 228 goes into effect, so does the correction to 228. So no harm, no foul. Anybody have any questions? Because it was, at least in the gun community, it was highly publicized. And that was a good fix for everybody because, again, because of old laws, and just the laws need reviewed and need updated. And that was all, because the only way in the past you could get a shotgun that was 26 inches, just over 26 inches, was to be sawn off the stock and cut in the barrel. Well, things are manufactured differently, and they came with a pistol grip, and that made them legal. Then another thing that was a great piece of legislation, we've all heard about the NICS checks that you have to get to purchase a firearm, where you do a background check. Well, what we did is the House and the Senate, the state of Ohio, passed enhanced penalties for attempting to purchase a firearm under disability. Now, what I mean by disability is it's not a physical disability, but it's a firearms disability. There's certain things that make it so you can never own a firearm again. A minor misdemeanor domestic violence, for example. Very controversial. You get in an argument with your wife, with your son, with your daughter, and you get a ticket. Well, that ticket means you can, for minor misdemeanor domestic violence, means you can never possess a firearm the rest of your life, and it can never be expunged. Or you were sentenced for a crime that you could have served, you were found guilty of a crime that you could have served more than a year in jail, so a year and 1 day. That puts you on a federal firearms disability. No matter what it is, even if you didn't get any jail time, you were put on probation, or you're a good person and so nothing happened, but the fact that they could have sentenced you for that long puts you under a firearms disability. Well, I'm on probation still. I haven't got a relief from that disability, which is a procedure after we've served our community control, our probation, our fines are over, our community service is over. We can get a relief from that disability, and then we can vote again. We can purchase firearms. We can do any number of things that a law-abiding citizen can do. Problem was, the federal government, when someone lied on a 4473, which is the form you fill out for the NICS check, the first question is, are you the intended purchaser of this gun? Well, if I'm going to purchase it for my brother, no, I'm not. I'm really not. Or I say yes, and the next question is, are you a convicted felon? And I lie and say no. Well, if I get caught lying, they run the test and say, or the run the next test and realize that, hey, wait a minute, you lied on this form, you're a convicted felon, you're under a firearms disability. Now the state of Ohio, the local police prosecutor can prosecute that person, that felon, or that person who's not supposed to have a firearm now to get a firearm. In the past, it was the federal government because it's a federal NICS check and it was federal regulation. And essentially, the state of Ohio could do something about it, but they didn't have any teeth or authority to really arrest or do anything. So this was a great piece of legislation, and make sure that the people that by law can't have firearms aren't going to get firearms, at least legally, or if they attempt to and get caught, there's going to be penalties for that. Yes.
Sean, our last class was on medical marijuana, and our speaker was unclear on what the ramifications were of having a prescription medical marijuana card on gun ownership.
You won't be owning them. There's a question on the 4473 that asks if you are a user of marijuana or any other substance like that. Despite the fact that you have a medically prescribed medical marijuana card, it's not recognized by the federal government. It's not legal by the federal government, so you lose your firearms rights, at least your ability to purchase that firearm when you're trying to do that. And if you try to get a concealed carry permit, you're going to get turned down also for that. That's something that I've discussed also with members of the Attorney General's office, and it's something that Mr. Becker's going to have to take care of, because try to take care of it. It's a federal law. Federal is going to control. So if you write that down on the next check, it's going to come back as a denial if you go to purchase a firearm. It's going to come back as a denial if you go to get your concealed carry permit. So there's a lot of things that can be done that would take care of that. Constitutional carry would be one of it, would take care of part of it. But I mean, that's something that we have to deal with. I have friends that live in Colorado, and I've been talking to them, asking them how they took care of it. I'm not quite sure yet, so I'm going to try to find out, because it's coming to the state of Ohio. Medical marijuana cards, and you're going to get turned down if you tell the truth on the 4473.
Thank you. And can you also tell us a little bit about your website? We've got it behind you.
Oh. Second Code Offense was an organization, a membership organization I started probably 7 years ago now. Remember how I told you I was a terrible businessman and I didn't charge people for a lot of things related to firearms? Well, I'm also an NRA instructor, and so I taught a basic pistol course, which is a requirement to get your concealed carry permit. I taught a young man. He was 22 years of age, and about a week later, I came home on a Friday evening, sat in a recliner that I had just gotten for my birthday, and was so happy to be Friday and I could relax. Well, the phone rang, and I picked it up. I answered the phone, and whoever was on the other end of the phone was sobbing so incoherently, I had no idea what they were trying to say to me. Being a criminal defense attorney, I said, hey, if you've been arrested, hand the phone to the police, which he did. And it was a Fairfield City police officer who said that he was charged with brandishing a firearm. The way it was a long, drawn-out story. He did brandish a firearm, but he had a legal right to do so. They charged him with felonious assault, which is an assault so bad that someone could potentially die. Well, it wasn't felonious assault, so they overcharged him, which meant that at 22 years of age, with a 22-year-old wife and 2 kids at home under the age of 4 years old, he was going to spend Friday until Monday morning in Butler County Jail. And I knew he would be changed for the rest of his life, and I couldn't let that happen. So his wife and I went door to door until about 2 or 3 in the morning. We went to everybody's house that we knew, that she knew, to get money to beg, borrow, or steal. We maxed out ATM cards. We did everything, and finally collected a $10,000 bond, contacted a bail bondsman, and got him out at 3 o'clock in the morning. And what people don't realize is what happens to that money that you pay for bond? It's gone. And as long as it took me, I said, there's got to be a better way to do this for law-abiding citizens who are wrongfully accused. And unfortunately, things get confusing. People are overcharged, not charged correctly, or charged when they never should be. So I said, there's got to be a better way to do it. So I started a membership organization that provides training and education. I have online seminars on lethal force and law. When is it legal for you to make that determination to use lethal force? I have one that's guns on the go, how to properly carry in automobiles from state to state, on airplanes, how to transport firearms. But I started thinking there's got to be a better way, and that's how I started Second Call Defense. And as part of a component of Second Call Defense, we started a foundation. And the foundation is funded, so if you're arrested, the second call defense, you're forced to use a firearm of self-defense, whether it's brandishing, threatening, or pulling the trigger. Call 911, get help on the way, call us. You're gonna talk to an attorney, we'll be on the phone with you when the police arrive, and then if you should happen to get arrested, we immediately post bond if a bond is available for you, provide the money that you need for an attorney, and also, if you don't have an attorney or don't know who an attorney is, I'll give you a list of the top 3 attorneys anywhere in the United States where the shooting takes place or where the use of self-defense takes place. We continue to provide funding and protection throughout the course of the trial, all the way through the jury verdict. And then we're reimbursed from by an insurance company, so we're not considered insurance because it's illegal to provide insurance coverage to somebody who uses a firearm or self-defense, or more particularly is a defendant in a criminal action. So I started it. We had to jump through a lot of hoops. I never understood how complicated insurance law was. I just wanted to take care of my friends. I figured if we all get involved to help each other out, we could do that. Of course, the government that ruins everything gets their hands involved with all the regulation, but we got it done. And so it's been in business for 7 years. There's a lot of other ones that have popped up also around that time, but we've done it, and we've paid some bills for some people.
Another question from John Beck.
Hey, Sean, actually, a couple of things. You talked about the lawsuit in Columbus. What I was thinking about as I was listening to that on the way home on the radio, and apparently they're suing on constitutional grounds regarding home rule. Mm-hmm. Now, the way the bill is written, and the state law would overrule home rule, my understanding, because it applies statewide. Right. So I can't imagine that getting any traction in the courts, but it will be entertaining to watch. Now, my question is, you were talking about constitutional carry. I haven't seen the bill, but my understanding of the bill, and correct me if I'm wrong here, is that if you are legally allowed to own a firearm, then under constitutional carry, you'll be legally allowed to carry that firearm concealed. The controversy with that gets into people with, and again, correct me here if I'm wrong, but people with 5th-degree felonies. So you got felony convicts or ex-cons out there that have a host of all kind of convictions that are only felony 5, say only. I mean, that's the lowest of a felony. So all these felons will now be allowed to carry firearms. Do you think it should be that open, or do you think it should be more restrictive, or where do you think we should come down on this?
Well, if you can legally own or possess a firearm, legally own it or possess it, it's right here, then constitutional carry applies to you. If we decide as a people that we don't want nonviolent 5th-degree felony people or whatever they are, if they can still own or possess a firearm, then that portion of the law needs to be changed. But the way it is if you can legally own or possess a firearm and you're not under a disability, then you can carry a firearm in the state of Ohio. And I think that's probably going to be up to you guys how to deal with things like that. But in my estimation, there's a lot of people that were charged with writing bad checks that they can't carry a firearm that have nothing to do with violence or anything else in society. So it's a determination we have to make, and we have to remember, and every time there's a gun tragedy, we have to remember, folks, we are the freest nation in the world. Because of that, we have certain rights and privileges that nobody else does. And because of that, bad things happen. But you can't punish 99% of everybody for that bad thing that a 0.01% did. And that's what you have to remember. Every woman, every mother, every daughter in this classroom has to understand that every time someone passes a bill that makes it harder to buy a gun, harder to possess a gun, harder to use a gun, they're taking your right to protect yourself away. I always tell people I'm pro-choice on self-defense. It's up to you how you protect yourself, and government has no place in your drawer telling you when, how, and if you will protect yourself. Plain and simple. We're American citizens, law-abiding citizens. Government has no place deciding how my mother, my daughter is going to make it home to me every night. And you have to fight for that passion all the time, because that's what they're trying to do. Every time Nancy Pelosi or anybody else comes up with a new anti-gun scheme, a new fee, a new ammunition tax, they're trying to take your rights away. They're trying to tell you how you have to protect yourself. I'm sorry, Nancy. You're not on my steps at 2 o'clock in the morning when some crackhead kicks my door open and is coming to kill my family. So don't you dare tell me how to protect myself. And that's what we have to think, and that's how we have to react every time they try to pass one of these lame brain pieces of legislation.
Question right here.
My name's John. Sean, will you represent USCCA members too, or?
As an attorney, I represent everybody. I know Tim Schmidt. We both started things right from the beginning. Unfortunately, I think if you'll pay me, obviously, yes.
We have another question here.
Knowing full well that I'll probably do it for free.
So I actually have a comment going back to Mr. Becker and your 5th degree felony. So and with all due respect, I feel like it's common sense. 5th degree felony or 1st degree felony or whatever degree felony, criminals don't follow laws. So I don't know how a law is going to make it better for felons to not carry guns.
And Mr. Becker's defense, and correct me if I'm wrong, that question dealt with there's a group of people out there that aren't going to want 5th degree felons to carry firearms. I mean, they're not like you and I, and you're exactly right. Laws are for the law-abiding folks. And that's why it's so important to realize that there's not a no-gun sign in the world that's going to keep a bad guy with a gun outside the door. There's not a 911 call in the world that's going to be there right now to protect us. We have to protect ourselves, and that's our job.
Yeah. Other questions for Sean? Anybody have another?
Hi, Sean. I'm kind of worried about this Connecticut deal where they want to go ahead and be able to sue, well, enable somebody to sue Remington. Also, banks are turning down loans to MO. I mean, this is a backdoor gun confiscation or even worse. While you and John here, is the state of Ohio, can the state of Ohio like put up some kind of a guard against this kind of action here in Ohio?
Well, unfortunately, what you're talking about with the banks is Operation Choke Point. They would get banks and other lending institutions to stop doing business with anybody that had anything to do with firearms. Because of capitalism, other places popped up that would do that for people with firearms, but that's been a problem. These other states have been a problem. Now, I haven't read the judge's decision in Connecticut enough. I know there's federal law to prevent that from happening, but from what I've heard or a paragraph of the syllabus that I read, it had something to do with the way Bushmaster Remington was marketing, and so they're trying to use a marketing way around it. Now, the lower courts obviously ruled the opposite direction, and the Supreme Court of Connecticut ruled the opposite direction. So I'm confident that's right for appeal under federal law, and it's not the last we've heard of that. But again, folks, elections matter, campaigns matter, who you vote for matters. I think probably it's safe to assume that nobody has done more for the United States judiciary than Donald Trump has done. Nobody has appointed so many judges, so many vacancies are filled, and there's hundreds and hundreds of more. We just got to keep that train rolling, because truly that's what's going to protect you and I and our grandkids.
Other questions right here?
I'm David, and this is a little bit on the side, but I was reading local laws. You're talking about laws being uniform in the state of Ohio. Mm-hmm. But I was reading local laws where I live, and it's illegal to discharge a firearm. I mean, how does that comply with a concealed carry if you have to use this thing? Are they going to get you on that, or?
No, when they're talking about, it's like in a township in Ohio, you can essentially shoot in your backyard with proper backstop and do it safely. When the laws that are for improper discharge of a firearm in the city limits and things like that aren't going to apply to concealed carry for someone who uses a firearm in self-defense. Stent Call Defense, we represented somebody in Dayton, Ohio, and there's a big brawl on a gun discharge, and nobody could tell who discharged the firearm. And the person that they decided must have done it was arrested, and he was immediately charged with improperly discharging a firearm within the city limits, inducing panic, and a number of other things. He was held the longest he could be held without being charged, and then he was released. He gets home a week later, and the city of Dayton mailed him a warrant to come back and answer for those charges. Since nobody had ever testified and no film had ever showed who in the world discharged the gun, he was released. But those laws like that although they're on the books, but they're not going to be enforced if you use a firearm in self-defense or something like that. That's for improperly discharging a firearm within the city limits. When you use a firearm legally in self-defense, there's really nothing improper about that, but that's a good question.
Here's a question right here.
Hi, I'm Bruce. We recently moved to southeast Indiana, and we routinely come back into Ohio. My permit in Ohio is still good, and now we have lifetime Indiana permits. Any advice on constantly crossing the state border?
Do you work in Indiana? I mean, do you work in Ohio?
No.
Okay, there was an exception put in law. John, was that 2 or 3 years ago? That if you worked in Ohio but were from Indiana, you could get one of Ohio's out-of-state permits, and that was the only reason why you can get it. Essentially, if you're carrying on an Ohio permit and your residence is no longer in Ohio, since Ohio doesn't issue out-of-state permits, you know, that's kind of questionable. Constitutional carry will take care of that. And then there's so many things that'll take care of it. And then I think probably if you're from Indiana and you get the proper training and it's similar to Ohio training, I think probably there should be an out-of-state permit issued to you in Indiana, because that's essentially why you're not recognized, is because you don't have the training requirement that meets Ohio's approval.
Question right here.
Richard, my question is about the signs on doors, no concealed carry. Not private businesses or courts, but public places like libraries and civic centers. Do they really have the authority to keep a person from concealed carry in those places?
Government buildings, unfortunately or fortunately, do not carry zones. However, they passed a piece of legislation a year ago that permits the government building to make the decision that, yes, we want to allow firearms in our township building, in our library, but it's up to them to make that. So yes, they can, because the government building is essentially a do not carry zone, but now it can be your local government's choice to allow carrying in a township building or meetings or in a government office building. Open carry is legal, but they can still pass a special ordinance to prevent open carry in those buildings, but open carry is legal in a government building.
We have another question here.
Oh, Dan, and hey, thanks for everything you do. OVI checkpoints. You're pulled over, you haven't been drinking. You haven't created a situation for, or they're not pulling you over for something you did, it's just a random pullover. Do I have to disclose at that point?
Any meaningful contact, yes. And I always tell people to remind any passengers in your automobile also need to inform the police officer that they're concealed carry permit holders and they have a firearm. And not only do you have to inform the first police officer that shows up, but every police officer you come in contact with, it's incumbent upon you to inform that you're a concealed carry holder and you're carrying a firearm. I represented an individual who was involved in a fender bender, and 4 different police cars responded to this one evening. It was still daylight. 3 officers he informed. Number 4 he didn't realize was number 4 and didn't recognize him, and at that time didn't disclose. And that 4th officer wrote him a ticket. That was taken care of by a common sense judge, but just be aware that you need to inform everybody.
We have time for 2 more questions right back here.
Yes, this is Michael. Just let this evening before I came. I know some email about a new bill, like, because I think it's B550, where they refer to it as the red flag bill, that anyone that determines that you might be a threat or whatever, they can call the law and they can come and confiscate everything you have. It looked to me like that could be a real problem.
Well, it is, and we talked about that soon. And to my knowledge, red flag hasn't been introduced yet, but of course, I'm not even sure if you guys are in committee yet. Yeah, they've touted federal, and I believe Indiana has a red flag law, and I believe California has a red flag law. There's certain red flag laws out there, and that's the problem. An anonymous phone call in some states, or from a relative or a household relative, a mere accusation, unfounded, could cause you to lose your firearms. until 3, 4, or 5, 6 days later when you get before a judge and you can prove that you're not crazy and you need to have your firearm. The problem with that is it's depriving you of your constitutional due process rights, among other things. And anytime, in my view, being an attorney for as long as I've been and seeing sometimes what happens to a nuclear family when they're drinking or they're fighting or they're emotional about something, I've seen people arrested for bald-faced lies before in the past. It's not too far of a stretch to think that someone would say, hey, my Uncle Henry, he's threatening people and he has guns. And so it's never a good idea to allow a mere accusation to interfere with a person's rights. And that's the balancing act that we have to take. And in my view, I'm not sure how that can be done because there are plenty of laws on the books. There's civil protection orders, there's criminal protection orders, there's pink slips. A police officer can involuntarily have you committed for a psychological evaluation if you're a danger to yourself and others. There's many things that are already in place on the books that police officers have at their disposal that they can use that have along with it due process protection. So again, somebody somewhere decided that a red flag law and taking guns away from people, because mostly I think it was Parkland. How many chances did they have to arrest this individual? How many times were the police called? How many times were at their house? They failed, but now they failed and it becomes our problem as it does so often. Real quick before the next question, you no longer have to, it goes into effect, if you're a concealed carry holder. In the past, you had to have 2 forms of ID, your concealed carry permit and another form of government ID. No longer your concealed carry permit is enough. You don't have to have 2 forms of ID. And also they've eliminated the requirement to post a no gun sign. So if you're a school that is allowing people to carry firearms, teachers to carry firearms into school, you're no longer required by law to have a no gun sign. Schools didn't want it. We're not a no gun sign. I've had some schools that have a 5x5 sign that says we're armed. And so they didn't want to put these no gun signs on their wall when they weren't. So that was changed also. So those are the most of the changes.
Next
We have a
question.
question here.
Hi, I'm Terry. I have a follow-up to Dan's question regarding if you're pulled over for whatever reason. If you have a passenger who is carrying and they don't declare, are you as the operator or owner of that vehicle responsible for that?
No, they're responsible because as a concealed carry permit holder, it's their responsibility to inform. The law doesn't impute the knowledge that you have knowledge of everybody in your car who's carrying. I can probably say with certainty that most people riding with me are going to be carrying.
Here's the last question.
My name is John. Don't police officers normally know when they pull you over whether you have a concealed carry license?
If they run your license plate and it's registered concealed carry holder, yes, they do. The sentencing provisions are bifurcated, which I meaning if they run your plate and they know that you're a concealed carry holder and you fail to promptly inform if you have a gun, well, because they had knowledge, it's going to be a misdemeanor. It's going to be a ticket. You're not going to lose your concealed carry permit. But if they didn't run and they didn't know and you failed to promptly inform, then I think it's an M4 and you automatically lose your concealed carry permit for 6 months and they're going to be in front of a judge. So yes, they do know. And the way I would take care of it, and I can't imagine any police officer out there, the first words out of my mouth are going to be, do you have a firearm in your car? That's an easy way to do it. And I'd be pretty cognizant of the fact that I'm probably going to be lied to the majority of the time. So
let's thank our guest, everyone. Sean Maloney, thank you so much. Thank you, Sean. Appreciate you coming. Just a couple quick things before we close tonight. For those of you who signed Bill Cunningham's card, thank you. If you didn't get a chance to sign it, it's going to be right up here. For all those people online tonight, you can send an email to info@empoweruohio.org with your best wishes to Bill, and we will include that with his well wishes. Don't forget to thank the people who let us watch their movie tonight. It would be a big help to them. Reviews are so important. And your article I talked about that's kind of fun, you can pick up on your way out. Let's give Sean one more round of applause. He's such a great speaker, such a great resource. And when Buckeye Firearms comes to do their session, open to the public, or we will send out a meeting request so you guys can come here and hear the great things that they've got to say. So thank you all for coming, and we look forward to seeing you next Tuesday night. Have a great night, everybody.